Hello, I'm Robert Emmett Hernan. I'm head of Blue Stack Productions, publisher of Irish Environment, an online magazine covering environmental matters on the island of Ireland. I'm here today in Dublin with Peter Sweetman. Peter, you're very welcome.
Thank you.
Peter, you're in some regards a very well-known person. Some would call you notorious. Some would call you heroic, as someone who's been very active in pursuing matters of importance to the environment in courts. And I want to talk to you about some of those cases, but first I want to ask you, how did you first get involved with protecting environmental issues here in Ireland?
There was a proposal in Naas to build what I would refer to as an integrated sausage factory. Food went in and sausages and shit came out. And I've always believed that you don't use the polite names for things. A dump is a dump. Pig slurry is pig shit. And always, never, it's the other side have invented the polite names for it. Because we went from dump, from tip to dump,
yes,
to landfill, to sanitary landfill.
Yes, yes.
Right. And it's still a dump.
Yes.
Right, and believe in that. So I got involved in this purely because it was had been on my grandfather's land. It was on the banks of the Liffey. It was, I thought, a crazy project. And I started, like everybody else, I started as an NIMBY. Now, relevant Monica Muller, who I work with on Shell completely, has devised a new acronym for NIMBY, being Next It Might Be You, which is so funnily very true. Everyone thinks it's not going to happen to them. Their way. And I have a problem with people having to spend money to actually protect their environment from people who want to make money out of them. That's fundamentally what I do.
Now, you've been involved in many cases over the years, but I thought we could focus on a couple of those, and then after we talk about a couple of these cases, I'd like to come back more to your role in this issue, because I think there's some differences between here and other places, and it's important. Now, obviously, the biggest role probably is the Shell Corrib case. And I wonder if you could just give us a broad overview of what that case has been about.
I got involved, I was asked to represent them, and then certain people didn't like me, but I stayed on representing Monica Muller. Specifically the original pipeline was 30 metres from her front door, and Monica came to Ireland, which is quite interesting, from the Ruhr, like 30 years ago, right? To get out of the rat race and finished up with Shell as a neighbour. You know, it's not quite what you expect. But anyway, so we voted. The initial one didn't go through. We had an oral hearing, which was probably, I would think, probably one of my biggest ever successes. The inspector recommended refusal on all grounds. Board Panola overturned the inspector and granted permission, except for one, well, not granted permission, refused permission on one point only. And that point actually is quite interesting. They wanted to put 600,000 tonnes of peat on top of a hill and hoped it'd stay there. The point, I think, that made the difference in the case, I turned round and I asked the expert, would you put 600,000 tonnes of milk on top of a hill and expect it to stay there? For which the barrister in question abused me, and then it was pointed out to him that there's twice as much solids in milk as there is in peat. I'd read the book on peat. I grew up, my mother's family owned a lot of the Bog of Allen at one stage, and I knew a little about peat, and luckily for us, in a way, the other side knew nothing. And that it was refused on those grounds. Frank Fahey, who was minister, gave permission to put the pipeline 70 metres from housing at 345 bar. It was unique in the world. The
pressurized.
Monica and I, as well as the Rossport Five, were injuncted in the High Court. I'm a legal person who believes in law. You don't break injunctions. You can't break the law and use the law. I'm very much a believer in that. We put up a robust defence at the case. The case was due for the full hearing was for a very early hearing date. The point of issue, which is really funny, because you never quite know where you're going to win. The CPO against the other people who had, the agreement with people who had agreed to sell to Shell was for a 14-metre way leave inside a 40-metre working width. The CPO was for a 14-metre wayleave inside a 40-metre deviation zone. Nobody told the engineers on the ground that they weren't the same. They came into Monica's land and they fenced the 40 metres. So we countersued them for aggravated trespass. And of course it was aggravated trespass. And this got tied up in the Rossboard 5 case.
Yes.
And when it came to sort of having to settle it, they suddenly realised they had to settle with us. So they withdrew the CPO from Monica's land, gave an undertaking not to go through her again, and that, well, they tried to go round into the bog, but that didn't work. They could, for various reasons. The board said the right angles were too right angle, right? But I think it was also the NPWS, the National Parks and Wildlife Service, fought that point very strong, because it was very important areas of bog. There was bog pools and such like in where they were going. Anyway, it was completely crazy. It also, a very narrow bog road, just about takes one car, was going to be produced to take 50 trucks an hour. Yeah. And it just wasn't, it was going to collapse and such like. And they couldn't extend it without a CPO, because Monica's share in the common, she owned both sides of the road. They'd always said at the very beginning they couldn't reduce the pressure from 345 bar.
That was a critical issue.
Yes,
case,
that was the critical issue, really. Yeah. The pipeline that was going round Monica's into the bog was then reduced to 100 bar, so they proved they could do it. And now it's going in a tunnel under the bay at 100 bar maximum. We meant it from the day one that we were never going to stop it, but the object was to make it safe. And we've made it an awful lot safer. Now, as the actual pipes that are being used were to carry the same pipes as the 345 bar, and now there's only 100 in them. It's probably the safest pipeline in the world. And particularly as it's now buried in the thing, and it's going to be covered in concrete as well. But it's been, what we have done, contrary to what people think, has been very beneficial to the local people, right? Because initially there were no local jobs. It was going to be a turnkey project by a Turkish company with huts on the site for the workers. And we got it from, initially based, it was to be costed 800 million. It's now cost over 3 billion. And a lot of that money has been left locally. Mr. Rabbit, who I refer to as the Rabbit.
This is the minister? Yes.
The minister, so-called minister. Thinks that we've cost them an awful lot in tax, but nobody's told the minister that Shell doesn't pay tax.
Yes.
They basically, he should have learned with the likes of Google and Facebook based here, they're not paying tax. That Shell certainly won't pay much tax. They'll sell the gas to an offshore company, and then they'll sell it back to one of their own, and basically all the profits will be made offshore. The entire project has never been in full compliance with European law. And it'll go ahead, but it still should be brought inside the law rather than outside the law. See, in Ireland, EIA is, in these sort of projects, EIA is split between, well, here it's split by more than that.
Yes.
They made a priceless mess of the legislation, actually. The EIA, Environmental Impact Assessment, for this project is carried out by Bord Panola. They do the planning issue with it. The Minister for the Environment does the foreshore licence. The Department of Communications does a bit of everything, nothing right, but a lot of bit of everything. And then the EPA do the discharge licence part of it. And the EPA being the last one in the line, under the judgment which was called 5009 in the European Court, somebody has to tie them all together. And as they're the last one in the line, it's up to them to get it right. And I don't think they could get it right.
Now let me switch another thing, because there's also another critical recent case that you were involved with, which was the Galway Route 6 bypass. And that you took to the European Court, which has been very different. And a different issue in a way, because it's more technical in a way.
In a way, it was actually, we won that on the basic principles. Rather than on technicalities.
And what was the case? Tell the audience what the case was.
Actually, we told the board, we told the Galway County Council back, I think, 10 years ago, that we were going to take them, and it wasn't going ahead, right? Because limestone pavement, which is what the burren is, right? Which is quite common in the west of Ireland, but is very, very uncommon in the rest of Europe. And the Habitats Directive is about the relevance of a habitat in the European context rather than in the Irish context. And this was taking away part of the limestone pavement. There was also another 20 hectares of other habitat which was being taken. But I concentrated the case, Greg and myself, Greg Casey was active for me at the time. We went totally on the basis of the limestone pavement because it was unrenewable. Once you take it away, it's gone. You couldn't put it somewhere. You couldn't create new habitat and such like on it. It took 3,000 years to create it. That wasn't around. So that's why we went for that. We went to the Board Panola hearing, fought that for 20-something days. The inspector and the board both found that it would have a significant effect in a localised manner. Well, that doesn't apply. Those terms but didn't quite apply in the Habitats Directive. Took it to the High Court, got a very good hearing from Justice Birmingham, who found against me, but immediately gave us a certificate to go to the Supreme Court. Went to the Supreme Court. Supreme Court referred it to Europe. It was the only time tears came out of my eyes in a court case. From success, I was used to being beaten, but I wasn't used to winning at that level. I never bothered with crying never had a tear for losing, but had a tear for winning, which is quite funny when you think of it. Got referred to Europe. Went through the process in Europe. Went over to the hearing in Europe, in Luxembourg. Most incredible thing going to the European Court was the quality of the questions from the judges. The difference was amazing. Particularly, you'd have to single out Eleanor Shopson, who was the Advocate General, who English, and listening to her, the questions she was asking, I came out of that very confident. The Advocate General's report came, it was very favourable. The judgment was very favourable. The judgment is now the judgment on the Habitats Directive in the European Court. It's the most important one according to the Commission.
And this is on that issue of whether the plan has impacts on the integrity of the site.
Yes.
That interpretation.
We interpret that the site is the site. It's the whole site.
Yes.
There've been cases, particularly one in Portugal, where a road went through the middle of an SPA and they sort of got away with it. But this basically would be, the Commission had always been arguing, their point was that you could destroy a habitat by death by 1,000 cuts. And this judgment actually stops that.
Yes, you can.
Yeah, and that's where it's now seems to be quoted very well. Somebody told me recently, and I'm not sure on this, that it's the only reference taken to the European Court on environmental grounds, which the individual, by an individual who didn't actually have anything to gain by it.
Yes.
That I took it purely in the common good and the defence of the Habitats Directive.
I want to come back to that, Peter, but first I just want to finish up on the process there. After the European Court of Justice upheld your position, it then, because it was just on certification from the Irish Supreme Court, it then went back to the Irish Supreme Court, and then what happened there?
They turned it over.
They quashed the
decision, lock, stock and barrel.
But just based on the European Court Justice.
Yes.
So that case is...
Case is over. Believe it or not, Galway County Council think they can still proceed with the same road.
Yeah.
They want to go. They're now going down what's called the 6-4 process, which is what they should have done in the first place. But where it's a priority habitat under 6-4, there has to be no alternative.
Yes. Yeah.
And there's always an alternative.
I mean, the impressive thing about the Galway By-Pass case is that, as opposed to Rossport, which was very critical for that local area and that local issue, this is a much broader application, not only in Ireland, but throughout the European Union.
Rossport is a local victory, and the Galway By-Pass is a European victory.
It's right.
Yeah.
And you were involved with both of them. And now I want to ask you is, how do you get standing to sue these? As you said, you had nothing to gain from the bypass case. So what legal basis do you have?
The legal basis here, once you participate in the process, where under the EIA directive, there's a basic section that the public shall be consulted. And Panola calls it observers or such like. I call it I refer to myself as the public being consulted. I believe that. And once you made your point and you've been consulted and such like, you have a right in the court.
So it's the initial entrance to the beginning of the case gives you the right to appeal it.
You have that right. One of the senior counsels, or actually for the state, actually it's a locus standi issue, right?
Yes.
And we used to have a substantial interest, right? And then under the Aarhus Convention, that has been changed to sufficient interest.
Okay.
No one's quite defined what the difference is, but I am told by one of the senior counsels who works for the state that he would consider that I have substantial interest in all habitats cases now. So we'll see. I haven't challenged that. I have one in the pipeline in the moment.
Now, have you ever been rejected as a litigant in the court for that standing issue?
No.
Okay.
I've never been thrown out in that.
Has anybody else, you know?
Yes.
In Ireland?
Yes. There's what's called the Harding case, where they came in at a late stage with this person who hadn't taken no part whatsoever, and his complaint was that he drove past the site in his boat and spoiled his view, and it wasn't it was in my opinion a very stupid case to take, because it was a case that, in my opinion, I have taken cases, probably involved in cases where you couldn't win, but you might make some point that's worthwhile.
Yes.
But don't get involved in cases where you can't win and you make bad law.
Yes.
That's my fundamental. Thou shalt not score an own goal, and the Harding case was an own goal.
And you know, Peter, the interesting thing about your victory in the Galway By-Pass case at the Supreme Court, where you were, obviously was very important to you, even to get it referred to.
It's the first time we've ever made a reference to the European Court.
Yes.
It's the only one.
On environmental issues.
On Ireland, yeah.
But also
there's one that's coming from a slightly different angle about pig shit at the moment. That's different. That's coming from a commercial and relevant waste.
And the only other comparable victory I can think about in the Irish Supreme Court is the John Hanrahan case, which was the farmer down in Tipperary who fought against the pharmaceutical company, who was lost at the High Court, but then in the Supreme Court he won in the Supreme Court. They overturned the High Court.
He made seminal law. The basic on that was that the level of proof in an environmental case was changed from being beyond reasonable doubt to in all probability.
Yeah.
And people don't realise it's a long time ago, but it was extremely important.
It was, yeah. Now, let me ask you this, because you mentioned in terms of the quality of the questioning you were getting from the judge and jury. Do you find that is there a developing expertise within the legal profession in Ireland, both within the solicitors and barristers and within the courts? One of the things, Peter, that we learned in the States is when the environmental law started in the 70s, it really took about a 10-year period for the expertise to develop within the judiciary as well as within the lawyers. Are you finding that happening at all?
There's a certain number of barristers and solicitors. Basically there's 3 solicitors who specialise in this sort of case, and there's a few barristers who are interested. They also have to make a living, because the Irish legal system, by its archaic system, is probably the most expensive in the world. It's certainly most expensive in Europe. It's even much more expensive even than England. You take my costs in Galway will probably come to over 400,000. So unless I had friends, I wouldn't be taking it.
But are you finding there are more lawyers who are having some experience with environmental stuff?
Yes, more lawyers, but not judges.
And not many judges.
Well, no, we have we have one judge who has a lot of planning experience on the angel side, right? We've had judges before who had planning experience, but one of them in particular had never taken a case except for a developer.
Yes.
You know, no experience of the other side at all, and you know, basically that was the type who are being promoted. The judges at the moment, it's hard to knock them, and I wouldn't knock them as such like, but the way the system operates, we need 2 or 3 judges specialising in environmental law. We need to have judges trained in European law, Irish legal teaching through the universities, through the Bar Council and the Law Society. My opinion is fundamentally flawed. I'm completely self-taught, with a lot of help from a lot of people, but I've come from European law down, and they've all been taught from Irish law up. And when the final decision is made in the European court, that's where you should be starting, not finishing. I believe you should start at the top and work down, because all environmental law in Ireland has come from European directives. The European directives are, well, the European law being different, are clarified in the European court. But we're inclined to ignore the fact that the European court has ever really existed in any other cases. And you know, it's a system whereby if there's any, it's dispute on interpretation is what the European court does, and does very well in my opinion. And you know, I was actually amazed at how brilliant they were.
Now, Tony, let me ask you this: we're both the same age, and neither of us quitting. So, what's up next for you?
I'm involved in, I think at the moment I'm involved in a planning inquiry, which is probably the biggest financial development ever proposed in Ireland, which is about 150 to 180 metre high wind turbines to produce electricity that we can't assimilate into the system. So we basically will be new subsidies for semi-state bodies by putting it on the electricity bill. Last year in 2012 and 12 we paid 142 million to turn off wind farms, or to not just turn them off, but also to keep the gas power stations spinning at what they call spinning reserve, because we have very bad wind in Ireland. We have gusts, like the south of Portugal, Spain and such like. They have nice hot air that moves consistently up from the Sahara, and they know week ahead what the wind's going to be doing. In Ireland, you don't know 5 minutes ahead. Certainly, where I live in the west, you don't know 5 minutes ahead what the wind's going to do. You go from a gale to a calm in minutes, and you can't assimilate this into the system. But the country basically is also too flat. We don't have adequate. We have the only reverse pumping storage is a tiny project in Turlock Hill. We're not going to be able to build any performance that sort of, because we don't actually have mountains.
But now,
by European standards, we have little hills.
Is the opposition to this wind project based on the siting of it, or is it a general opposition to wind farms across the country?
Well, I'd be representing the local people in there's 2 separate wind farms. One is a development by what they call Board Namona and the ESB, which is the Turf Board and the ESB jointly. It's on land that had been, it's quite interesting actually, it had been land that had been excavated for a peat burning station at Corrib, which my father was the person who gave the final the approval to build it. He was Minister for Finance in the 50s, and he was also a lawyer. He was a solicitor, and this is probably where a lot of my advantages over the ordinary person came, because when we argued at home, we argued in legalese.
Yes.
And you know, my father had a photographic memory. He could look at one number in a phone book and tell you that every number on the page a year later. And it was very difficult to have an argument with him, so I got quite good at it. It was good training. I never won. So when it came to fighting these things initially, I didn't expect to win.
But it's the opposition to these.
The opposition is
based on siting, or
local, and there's a lot of local opposition to it. One was granted permission on the site in 2004 for a smaller operation, which never actually got built because they didn't have the power lines to take the power out. In real honesty, the opposition is based on the power lines more than on the wind turbines. People have suddenly realised that
because of the pylons?
Pylons are not a good thing in a
Right.
habitable area.
Right.
And basically we had very bad planning law in Ireland, right? We built thousands of one-off houses all around the country. And I'm afraid the problem is now they're paying for it.
Yes.
You know, it was bad planning caused the fact that you can't put a 400 kV line across land in Ireland without going too close to houses, because we built a lot of the houses shouldn't have been built. And I'm gloating over it in a way because I was opposed to one-off. You look at England, which has 10 times, 50 times the density that we have, right? And they have vast tracts of countryside. We don't have any.
Thanks for talking with us today.
Okay, thank you.